It is undoubtedly one of the most common, yet deceptively complex, scenarios presented in criminal law examinations today. V is highly intoxicated but conscious. Discuss D's liability for rape. When reading these facts, there is often an immediate instinct to move directly toward a conviction. It is easy to assume that because a complainant has consumed a high volume of alcohol, their legal ability to consent has been automatically nullified. In English criminal law, relying on that biological assumption is a severe doctrinal error. Voluntary intoxication does not provide a legal shortcut to proving vitiated consent. Analysis that relies on this assumption fails because it prioritizes moral intuition over statutory rigor. To understand why, we must start with the legislative origin of the law, Parliament. The governing legislation is Section 74 of the Sexual Offences Act 2003. The statute defines consent as occurring when a person agrees by choice and has the freedom and capacity to make that choice. This places the focus on two complex requirements, freedom and capacity. The central question is how the law measures this capacity when chemical intoxicants are involved. The primary authority for interpreting these boundaries is the 2007 case of R. v. Bree. While Parliament defines the standard of capacity, the Court of Appeal established the legal framework for applying it to intoxicated complainants. This judgment comes from the Court of Appeal, setting a binding precedent for lower courts. We can dissect the ruling using the IRAC method: issue, rule, application, and conclusion. First, the issue. V and D engaged in intercourse while V was heavily intoxicated. The defendant argued that although V was drunk, she remained legally lucid enough to consent to the act. At the trial level, D was convicted of rape. D appealed the conviction. The appeal questioned the trial judge's specific instructions to the jury regarding the complainant's state of mind. The core issue was whether the jury was legally equipped to evaluate her mental capacity at the specific moment of intercourse. In the rule phase, we look to the dicta of Sir Ivor Judge P. He established that a complainant can be severely intoxicated and still legally retain the ability to consent. This chart represents the grid system, a misconception that suggests capacity declines in a linear fashion relative to alcohol consumption. The court explicitly rejected this. It is unrealistic to link legal consent to a specific volume of alcohol. Under the law, capacity is only vitiated if the intoxication physically or mentally removes the actual ability to make a choice. Importantly, the court noted that capacity to consent can disappear completely while a person is still awake. This requires a qualitative assessment of the individual's mind, rather than a quantitative measurement of their blood alcohol level. The legal boundary of capacity acts as a cognitive switch, not a sliding biological dial. Applying this rule to the original trial reveals why the conviction could not stand. The trial judge failed to provide the jury with a clear direction on this specific timeline of capacity. Without that direction, the jury could not properly distinguish between a drunken decision and the total evaporation of legal capacity. This brings us to the conclusion. The Court of Appeal allowed the appeal and quashed the conviction. A conviction is unsafe if a jury is permitted to rely on common assumptions about drunkenness rather than the statutory test for capacity. To apply these principles effectively, you must focus on the jurisprudential reality of Section 74. The core takeaway is that intoxication does not automatically vitiate consent. Evaluating capacity is an intensely fact-specific inquiry. It centers on the actual state of mind of the individuals involved at the exact time of the act. Legal analysis requires investigating the moment consent was given, rather than simply counting the drinks consumed. Finally, consider three critical pitfalls to avoid in your analysis. First, stating that a complainant could not consent simply because they were intoxicated is a fundamental error. Second, you must differentiate drunken consent, which remains valid, from a lack of capacity due to drink. Third, search the facts for evidence that capacity evaporated before the victim lost consciousness. Success in this area of law requires precise application of the statute, favoring doctrinal accuracy over generalized assumptions.